Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm reviewing a book which has come to us from Edward Elgar Publishing in Cheltenham. They're an independent publishers and they produce very high quality legal research materials. And this one is part of the research handbook series from covering European law, and it's entitled The Research Handbook on European Union Law and Human Rights. It's this book here. Now it's been edited by two people, and I'm going to have a problem pronouncing the names. Sionad Douglas Scott and Nicholas Hatzitz, and I hope I pronounced the names correctly, but thank you both editors for the work you've done and also the contributors involved in it. The book's available as a book and an e-book, and I've given it the title. Elizabeth and I talked about the book, and I've given it a title headline for our book review: The Twin Evils for the Brexiteer, Compared and Contrasted Brilliantly, by Edward Elgar Publishing. That's, of course, EU and human rights. Now, these are two bête noirs to a lot of people. Not me, I hasten to add, but they are to a lot of people. And so it's really nice to have a book of this calibre available to us when we're deliberating some of the most momentous decisions that we're having to take since the end of World War II. Now, this is the book here. It's a hardback. You can see there, nice blue cover. There's the front of it. Now the spine is there. It's a heavy book, actually, surprisingly. And there's a lot of information on the back. I'm just putting it there. You can see some of the quotes that are there at the back, and then there's a bit of blurb at the bottom. I borrowed some of the content to assist. There are two comments, and Sir David Edward and Takis Tridimas have given some very nice quotes about this book. It's a heavy book, as I say. It runs to some nearly 550 pages. The index at the back is by page numbering, and again, that's quite useful. There's the index itself. Then you get the standard house style for Edward Elgar. There's always a conclusion. There are numbers for the subheads, and of course there's a lot of footnoting. But it is very much the style of and the structure of Elgar to produce works of this nature. The front of the book, there's the list of all of the research handbooks in this series. It's the research handbooks in European law there. Then you've got the front page there. You've got detail about the online availability of the book, and then you've got the various parts that make up the contents section: the framework beyond the European Union and EU action and new directives in fundamental rights. 23 chapters in total, and then you've got the contributors, a large number of them. I can't go through all of their names, but they're all to be congratulated on producing excellent work. Then you've got tables of cases from what was originally Court of Justice. Now, of course, it's changed its title a little bit, but it's the original case law. And then you've got after that legislation, of course, which is very helpful. And then after that we get to the actual introduction itself. And it starts off: the place of human rights in EU law has been a central issue in contemporary debates about the character of the European Union as a political organisation. And that's a fundamental point. I'm going to be repeating that later on, but it's a fundamental point about where we are at the moment, because this is a political issue, and obviously there are major changes with Britain's withdrawal from the European Union. You see the middle of the book: remedies under the EU Charter of Fundamental Rights. There you go. We're at a big crossroads in this country with our decision to leave. We've also got the whole problem of antipathy towards human rights in some areas of British society. So there's a lot to play for at the moment. So what do I say about the book? Well, this, without a doubt, the long-awaited research book for our times has arrived, with the twin evils for some, brilliantly covered here by Edward Elgar Publishing as part of their series of research handbooks in European law, and that's namely the two evils: EU law and human rights. Now, the editors comment in the introduction that the place of human rights in EU law has been a central issue in contemporary debates. I've mentioned this before, I will repeat it: in contemporary debates about the character of the European Union as a political organisation. Now remember that the EU originally started out as a trading organisation, and the very fact that they're using the words political organisation is red rag to the Brexiteer immediately. But that's one of the difficulties. Now bear that in mind, because you can't get away from the fact that the EU is actually a political organisation. It started off purely as trade, but it's changed, and it changed after Lisbon and Maastricht. Now, to set out their stall then, the 29 contributors have come together to produce the research material here, and without their enthusiasm, the book would not have been possible. It does make our task, I think, much easier to have publications of this standard available to us at a difficult time for both the EU and human rights itself. The collection of essays has been splendidly edited by Douglas Scott and Hatzius, and explores the principles underlying fundamental rights norms and the way such norms operate in the case law of the Court of Justice of the European Union, the CJEU. And that's at a time of major change and conflict for the UK as we are on the verge of leaving, because the sticking point has been the binding nature of CJEU decisions, and that's not been sorted out yet. Now, the 29 leading scholars in the field have come forward to produce this handbook discussing both the effect of rights on substantive areas of EU law and the role of EU institutions in protecting them. And the structure of the handbook has 3 parts, with the aim being to examine the current state of the law as well as the direction of future developments in the field, which we feel will attract a wide and varied readership. And this is not just a book, therefore, in my view, for lawyers. This is for political scientists as well, because there is very much of an overlap here. Now, the first part of the book discusses the normative and doctrinal framework for the protection of human rights in the EU. Again, where we are in Britain or the UK over that, I have no idea. The second, because everything's going to change, let's face it, but over a long period of time. The second part focuses on EU external relations and on the interaction between EU law and other sources of human rights rules, such as the European Convention on Human Rights and international law itself. Never forget, of course, the UN Charter on Human Rights, which quite often is completely ignored in all of this, and that was the forerunner of all of it. Now, the third part considers the influence of human rights in areas where the European Union takes action, as the editors put it. And again, I feel that those 3 parts together, because this is a high level discussion academically, it's a very scholastic book, but you are getting with this fairly heavyweight opinions. Let me conclude by saying it's both timely and astute for lawyers and politicians, this book, and will appeal, I think, to both undergraduates and scholars alike who specialise in European law and human rights issues, including learners who now have these areas as compulsory subjects for their studies. I was lucky I didn't have to do it. I chose to do it because it was a very interesting area of international trade and EU EEC law, as it then was, being developed. But that's decades ago, and things have changed. Now, what we get here is a valuable and a comprehensive additional resource for practitioners, policymakers, NGOs and government officials now sort of involved in the system during what is a period of massive European upheaval, and it's going to continue for some time. The publication date is stated at 2017. I'm recording this in the late summer of 2017. The book's available in a printed form and as an e-book, and I've been very pleased with it. I didn't find it that difficult to read, actually. Let's look at it again. There's the front of it, the spine, and then the back. I didn't find it difficult to read. If I just open it up, obviously you've got quite a lot of detail. You can see the footnotes there. You've got a lot of words as well, which probably, unless you are absolutely fairly heavily involved in EU law, and the way in which the human rights legislation and the concepts work, it may be a little difficulty. The autonomy focus of the CJEU, that, I've just opened it, right, I mean, that of course is where we are at the moment in the summer-autumn of 2017, with a huge row about whether CJEU case law should be binding on Britain in the future. The question is, it will at the moment, but once we leave, it's not going to. The question really, the squabbling, is about when it stops. But alas, you can see that the decision has been made to go, and that's the way it is. I thought this was a very good book, but you do need to have, obviously, some basic understanding of how the systems and the organisations work before you use it. But I would like to thank Elgar for what is a really high quality publication again from them. You make our lives a lot easier by producing these works. The research content is absolutely at the top, and long may you continue producing these research handbooks for us. We're very grateful to you for this one in particular, just coming out at the right time. Thank you to all. Bye-bye.